Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for sanctions nerds and normal human beings alike. I am your host, Brian Fleming. I'm here with my friend, colleague, and co-host, Mr. Tim O'Toole. What is up, Tim?
What is up, Brian? It has been a long, long road to the 4th of July.
It has. Yes. Quarantine. In the age of quarantine, time has lost all meaning, and we're recording this Monday, July 6th. So we're just coming out of the 4th of July holiday weekend. Hope everybody out there, wherever you are, certainly anybody in the States, had a nice weekend, was able to get out and enjoy some fresh air with your mask on at a socially appropriate distance from whoever else was out and about. But it is a long time to get here this year, more than most. But welcome to everybody to the latest episode of Embargoed. Thanks again to everybody for your continued support, comments that we're getting on social media, email, texts, etc. We really appreciate it. Would certainly encourage everybody in that vein, if you're listening to the pod, you're watching us on YouTube, our friends at Heartcast Media are gonna, we're told, add a few bells and whistles to the production this week, so you may be enjoying that as we speak. But please give us a rating, hopefully a 5-star rating. Subscribe so that you can get our new content every 2 weeks. And again, you can find us wherever you get your pods: Apple, Spotify, Google, Stitcher, Overcast, etc. And again, appreciate the continued support. So just to dispense with the normal formalities, we are not here giving legal advice, no confidential information being discussed, and just to take us through kind of the normal roadmap process here, in case you want to skip to anything. Surprise, surprise, most of our content today is going to be China focused, as it has been for much of the last couple months. We're going to start off with the latest from Hong Kong. Some big developments in the last 2 weeks since we last recorded. So we'll start with Hong Kong. We're going to move to the guidance that was put out by BIS relating to the new military end use and end user rules. Then we're going to go to an advisory that was just put out, a joint advisory by several agencies relating to forced labor in China last week. Sort of an interesting development that ties into a lot of things that we've been talking about recently. And then that's going to conclude our program. We think those 3 topics will probably take us quite a while to work our way through. And then the lightning round is going to be especially lightning this week. We're going to hit a joint Venezuela-Iran topic to start, and then we're going to circle back to one of our favorite topics, of course, Huawei. So with that,
we can't do a show without Huawei, and we can't do a show without really focusing on China.
We can't.
It's where it's happening right now.
For better, for worse, that is the world we are living in 2020, July of 2020. So any thoughts before we kick off, Tim?
No, I mean, I'm just struck by how we keep coming back to China, but that really is all that is going on in the trade world right now, or at least 90% of it.
It's certainly casting a long shadow across everything that we see and hear. So with that, let's jump into item number 1, which, as I said, was Hong Kong. So we covered Hong Kong pretty extensively a couple of episodes back, as we talked about the latest developments there, the statements by various U.S. government officials about the threats to suspend Hong Kong's special status, the rumored sanctions bill, etc., which were all in response to the actions taken by the Chinese central government to impose I think fair to say, unwanted and unanticipated, at least until very recently, security bill on Hong Kong that is going to permit the Chinese government to have far greater influence on certain critical aspects of Hong Kong life, not the least of which are the ability to crack down on pro-democracy protesters in Hong Kong, and also the ability to intervene in other types of legal affairs in Hong Kong. And also, as we'll talk about in a minute, perhaps extend its reach now that the law has actually been passed, extend its reach to beyond Hong Kong's shoulders to go after foreigners who try to incite action in Hong Kong or take pro-democracy stances, anti-China stances, et cetera. So all spurred on by that legislation, that bill, which just in fact was passed about a week ago in China. And so quickly on the heels of that, a couple of big responses from the US. So number one, that special status for Hong Kong has in fact now been suspended, and we'll talk about what that means in a minute. The Commerce Department came out right away with a statement relating to the export control treatment that Hong Kong is now going to receive under the Export Administration Regulations, and we'll cover that in a second. And then the second piece is later in the week, just a few days ago now, the Hong Kong Autonomy Act passed both houses of Congress and is presumably sitting, at least metaphorically, on the president's desk at the moment, if not literally, and is awaiting signing by the president. Now, notably, the president and the White House did not come out right away and indicate support for that law or a firm view on whether it was going to be signed. As a practical matter, it's going to be signed because both houses passed it unanimously, I believe. I think it was a total whitewash in both houses by voice vote only. So this is veto proof and is going to become a law. And it's just a question of how long it takes the president to sign it, I think. So those are two pretty big developments. And in particular, and we'll save some of this for the second part of our conversation about Hong Kong here, but as we sort of hinted at when we first talked about the prospect of a Hong Kong sanctions law a few weeks ago, this one does have in its purview financial institutions. And so that is a big development. That is a major step in terms of giving any Hong Kong related sanctions real teeth from a US sanctions perspective. And so that we'll talk about that a bit more in a moment. But let me circle back to you, Tim, on just before we jump into the BIS announcement about the export control changes and the fact that license exceptions relating to Hong Kong have now been suspended and gone away. Where do you want to start here? What are your sort of first thoughts on all this, just relating to what just happened, what just transpired in the last few days with respect to Hong Kong?
Well, I mean, let me just start with kind of a personal thought on this. I mean, Hong Kong is just one of the most interesting, fun, weird, like just an incredible city and kind of a mix between East and West. And just, it has all sorts of unique aspects to it that really, the whole thing that's going on with Hong Kong really in the last year has made me very sad. With respect to the trade developments in particular, I do think on a really high level, we have to think about whether or not these trade elements are really the beginning of a move from Hong Kong being kind of the hub of Western trade with China, and certainly, US and UK trade with China, to moving that trade somewhere else, be it Singapore or somewhere else in Asia. I mean, and I think that is really what is potentially at stake here, because both in connection with sanctions policies and export policies, the U.S. attitude toward China and the U.S. attitude toward Hong Kong, just as a foreign policy matter, have been very different really until the last 2 weeks, and they've been changing. But I think that the last 2 weeks have really galvanized in the U.S., and it's not just the U.S. There have been another number of other Western countries that have started this move towards treating Hong Kong as though it's China. And to the extent that happens, I really do wonder what it's going to do generally to change Hong Kong's status, not just from a trade perspective, but from the way the city is set up. Is it going to be just another city in China? And I think that the answer is probably yes, unless some of these sanctions change behavior. And I think we should probably talk about that maybe at the end. But I think that to me, the chances that the sanctions policy here are really going to change behavior are close to zero.
Yeah, I mean, I think that's all well said. I think if you look at So sort of two things to sort of think about here, and to we hope that there are most people here who've listening have had a chance to visit Hong Kong. Tim and I have been there multiple times and have many people that we're in touch with there on a fairly regular basis. So when he notes that this is sort of sad, it is on a personal level, I think, for both of us. But I would say that, so just let me talk for 1 second about the Chinese law that is sort of driving all this first. So I think there is, from what I understand, and I have not tried to read, I've read a translated copy, and I've read a lot of reporting on the law itself, but obviously we're not Chinese legal experts, but there's a lot of ambiguity and a lot of sort of fluidity and play in the joints that's there, which as a general matter tends to signal trouble, because it just means that the people who are sort of behind the curtain pulling the strings are able to sort of interpret this as they see fit, and there's not a lot of sort of predictability, regularity, and consistency to how the law may be applied. So that's, I think, what is driven most, U.S. and other Western fears about what this is going to mean in the future. And so that's certainly one big problem area. I think on the other side of it, on the U.S. sanction side of this, with the Hong Kong Autonomy Act that presumably is going to be a law very soon, the the scope there is similarly pretty broad. And as Tim said, we'll see. So far, there has been no evidence whatsoever from any of the actions the U.S. government has really taken within, whether it's on the sanctions front or the export controls front or anything else, that the Chinese government is really going to any of these things are going to bring the Chinese government to heel. Chinese government is going to do what they are going to do, what they think is in the best interest of China, and they will wage a war of words with the U.S., but they're not necessarily going to change their conduct unless there were something really drastic that were to happen. And I don't see this being it. I think this certainly gives the possibility that OFAC may at some point, and that the U.S. government may at some point, have many Chinese officials and others in Hong Kong and elsewhere subject to sanctions under this act. There is, like the Uyghur Human Rights Bill that we talked about a few weeks ago, and the most recent Hong Kong Act that was passed in 2019, there was a reporting period. The State Department's supposed to issue a report within 90 days about individuals that are part of the degradation of sort of China's promises to keep Hong Kong autonomous. As we know, we'll see if they actually meet that deadline. That's going to put us, not surprisingly, right around election time, and there's a lot of other things going on. So I'm not holding my breath that we're getting a report from the State Department on this in 90 days. And then within 60 days thereafter, the Treasury Department is supposed to issue a report with financial institutions that are engaging in significant transactions with those individuals. So that, too, I think I would not be holding my breath that we're getting that on that timeline.
We're still waiting for the Nord Stream 2 report.
Yeah, there's lots of reports we're waiting for from those agencies and many others. So that's a long-winded way of saying, I don't, again, as a symbolic gesture, this is a big move, a big step. What is this really going to mean in the short term in terms of how energetically this is all going to be enforced remains to be seen, and how much in the long term this is really going to impact anything also remains to be seen. I don't have a lot of faith right now that this is, despite the fact that there is unified agreement in U.S. policymaking circles, which of course there's agreement on literally nothing in the U.S. Congress other than this, it would seem to me, that this, there may not be much of a ripple effect on with respect to Hong Kong. Now, if there's larger international pressure, perhaps it gets brought to bear. Maybe in the long term that could do something, but we're not going to know for a while. And others, I think Tim alluded to the fact that other countries have kind of started to line up in this way. I know Canada, I believe, has announced something similar to the position the U.S. has announced with respect to its treatment of Hong Kong. I think other countries are either contemplating or have announced the same. So we'll have to see. But again, I don't foresee China changing its behavior. And now that it has it has its sort of a foothold in, its toes over the line, and this is the response. I don't know that much that we're talking about here is gonna make them backtrack.
Yeah, I mean, with all sanctions policies, you have to kind of think, what can we possibly accomplish in putting the sanctions into place? I mean, we imposed sanctions against China, some form of trade sanctions, all the way back to Tiananmen Square. There wasn't a China sanction program, but there's been an arms embargo in place since the Tiananmen Square actions, and those obviously didn't really change the behavior of the Chinese government with respect to human rights over the years. We adopted the Uyghur sanctions program fairly recently, and we're going to talk more about kind of some of the ripple effects of that. And sanctions are pretty good at accomplishing limited goals if you've got kind of a plan, particularly if they're multilateral sanctions and you've got a plan in place where you put them into place. They're really powerful when you put them into place. You tell the other side what it's going to need to do in order to get out from under the sanctions. Here you've got some of that. I mean, I think it's pretty clear that what caused these sanctions to go into place was the passage of the national security law. I think if China were to back off from that, that these sanctions would be lifted, presumably. But China passed the law knowing that these sanctions were going to go into place, and it seems unlikely, in my view, unless there's a much bigger multilateral effort to enforce these, and unless they're really ramped up, because the way that the Autonomy Act works, as you pointed out, Brian, is so the OFAC can sanction individuals within the Chinese government who are responsible for essentially the national security law. And they do that, and then the Treasury is empowered and the State Department is empowered to impose secondary sanctions against foreign financial institutions that facilitate significant transactions on behalf of some of the sanctioned Chinese individuals. So there's a couple of steps. First, they've got to sanction, and those are all probably going to be preceded by a report. First, there's reports on both of those issues. Then there's sanctions imposed first on the individuals or the entities that are responsible for the national security law. Then you have the sanctions imposed on the financial institutions that help them. That's how you build the infrastructure. That will take several years, I would suspect, to put into place. And then you've got to get a global consensus on behalf of that. At that point, the national security law has been in place in Hong Kong for 4, 5, 6 years. Hong Kong presumably will have moved on and kind of accepted the fact or that it has become part of China, and that despite the agreement that the British made when they left with China, that there would be basically, one country, two systems, that we've gone pretty quickly to one country, one system. It just seems unlikely to me that that's going to work, even though these are relatively powerful sanctions. They were put into place so quickly and without much of a plan as to how to change behavior and what sort of incentives could be put into place, that I just think what's more likely about this is they're almost more likely to speed the integration of Hong Kong and China than to stop it, because realistically for them to work, they'd stop it in 4, 5, 6 years once you put the structure into place.
Yeah, I think another thing to keep in mind that we've touched on a number of times over the last few episodes is the idea that I don't want to go so far as to say that China relishes this, but they are certainly taking great pleasure from all of the public statements and other things that are coming out from state media and other sources in China, trying to turn this back on the U.S. and call the U.S. a bunch of hypocrites.
Right.
And so I don't know that they really feel like, to the extent that the U.S. has made it its point to play sort of the moral high ground on these human rights issues over the years. That is certainly in the eyes of China and many around the world on very tenuous footing these days. And so I don't know, there's going to have to be a lot of other changes before that perception may shift. And as a result, I think that has, to your point, the idea that a multilateral sanctions regime is almost, clearly the most preferable, the most effective. I just can't see that really coalescing here, despite the fact that I think most agree that Hong Kong is getting a bit of a raw deal in all this.
Well, I mean, it is difficult for the current administration to convince the rest of the world that first and foremost among U.S. policy interests is to ensure the protection of peaceful protesters. Um, that's really a lot of what this is about, because the security law was passed by the Chinese government ultimately, but was tried to be forced on the Hong Kong government to go after protest and to go after dissent in Hong Kong. And, historically, the United States has been a big leader around the world in trying to protect the right to free expression, the right to peaceably assemble. Um, right now is a hard time for the U.S. to convince the rest of the world that it's so serious about that they had to join a U.S. coalition to go against the second biggest economy in the world and to essentially fight a battle on that issue. It's just, I think that the timing from the Chinese perspective of all of this could not be better. And I suspect that the timing that they decided to pass the national security law, since it's totally within their control, was not coincidental.
Opportunistic, yes. So before we segue to the next topic, let me just sort of pivot back to the first sort of item that I brought up, which was the change in the export control treatment of Hong Kong, as we sort of touched upon earlier. I think worth noting as well that this also could not come at a worse time for Hong Kong in terms of the fact that the U.S. is now applying harsher treatment to exports to China than it ever has. And we're going to, in 2 minutes, we're going to talk about some of the guidance that BIS just issued on exactly that point. So just before we sort of formally switch topics, any sort of final thoughts on that aspect of it?
Yeah, I mean, I think it goes to the point that we were discussing before about the fact that once you go down this road from the U.S. perspective, it's going to be very hard to go back. I mean, we've got now, you have clients, I have clients that are all scrambling to figure out what they're exporting to Hong Kong and actually conform it to what they're exporting to China. And those same clients are, as we'll talk about in a second, scrambling to figure out what they can
What
and
they're
can't
exporting
export
to China.
to China. But once they do that, and once you kind of line U.S. exporters up to treat Hong Kong like China, and this is likely to last for at least as long as the national security law lasts, the prospect of going backwards just isn't very realistic. I mean, once this change has been made, it's going to be very, very hard to turn around. And so in some sense, this change should please China greatly. Now, I do worry from China's perspective that this may wind up killing the golden goose. And so I think in the long term, there's some chance, and maybe a good chance, that Hong Kong is not going to be the economically powerful city that it has been in the past, or city-state that it's been in the past. But I think from China's perspective, to the extent China's goal is to incorporate Hong Kong within the rest of the country, that U.S. export policy now does that formally. And I don't think it makes China very sad for that to happen. And I think the fact that it's likely permanent is not going to make China very sad either.
Yeah. So with that, on that happy note, let's pivot to item number 2, which I will hand over to Tim, because as of this is another topic that we addressed on at some length in a recent episode. We're not going to rehash all of that, but as of a week ago today, as of June 29, we had effective the new BIS rules relating to military end users and uses, and lo and behold, just 1 business day ahead of that, BIS released some guidance. So that's what we're going to get into now.
Yeah, so this is just to kind of quickly rehash what we talked about. The 2-second elevator version of that is that back in, I think, April, the Commerce Department passed a proposed new regulation that became effective on June 29th, which greatly restricted exports to China of a number of products. So it added the number of products and then added a restriction to exports to military end users. And it also broadened the restrictions on exports to military end uses. But for here, I really want to talk about military end users, because I think that's the thing that has created the most confusion and the area that most of the guidance was aimed at. The reason that this created confusion was because the definition of military end users, which has not been amended, applies to things that you would actually think of as the military, like the Army, the Navy, the Air Force, the Marines, the Coast Guard, and even the National Police, but they define it. And then they have any other entity whose actions or functions serve military end uses. And that, as we talked about, kind of at length in one of the earlier podcasts, that definition is potentially really broad when you combine it with the fact that there's a lot of civilian military integration in China. And so you have research institutions, universities in China, not too different from what happens here. They do some work for the military. And so if your customer is an end user that's a university, if your customer is an end user that is a hospital that might sometimes serve the military, does the fact that your customer has one department or one branch of it that does work for the military, does that mean they're a military end user? And we were very confused. I think we talked about why the answer to that was confusing, and we had hoped that they would give us kind of a firm answer of no to that question, because you really should be looking at military end uses as opposed to this broad military end user concept. But the guidance did not answer the question in that way, and in fact, at least in my view, created almost more confusion. I mean, it did address this question that we had raised in the podcast, which was, say you've got a university, and the university does some military research in one branch, but you're dealing with an entirely separate branch, and they pose that as a frequently asked question. But the answer was maybe. I mean, maybe it's a military end user, maybe it's not. Here are the relevant factors, and one of which is you look at the specific department that you're dealing with. But they also said if the university is doing military research, that's a relevant factor. They told you to look at the individual, which is kind of weird guidance, because is it going to be professor by professor? And so if you have a professor that's never done any military research, does that is apparently a relevant factor, although that seems pretty hard to justify in terms of the ability for diversion in that set of circumstances seems pretty high, if you ask me. So basically they gave us some guidance. They told us what factors to look at, but it was like kind of the main answer was like the joke of an economist's answer, which is it depends, was the answer to almost every single one of these frequently asked questions. I guess the other thing that jumped out at me as being kind of interesting is what the new rule did was that it essentially created a licensing requirement. So if you're going to sell certain products to a military end user in China, you have to figure out that they're a military end user. And if they are, then you have to go to the Commerce Department to get a license. And what the new rules said in its language was that there was a presumption that the license would be denied, which caused us both to believe, I think, that it would be very hard to get a license. But the new guidance also seems to say it depends on that. I mean, they do acknowledge the presumption of denial, but then they make it sound like that doesn't necessarily mean your license will be presumptively denied. So it's still a lot of confusion. I think what we know for sure is that companies, especially early on, are going to have to err almost on the side of treating a lot of institutions in China that you wouldn't normally equate with military end users as potentially military end users, and the Commerce Department is going to see a ton of license applications trying to sort this out, because the guidance doesn't get you there. Because I've worked through a lot of these concrete examples, as I'm sure you have, and at the end of the day, when you parse through the guidance and you apply it to particular exports to China, if your client's got items that are on the list, the answer almost always is, boy, it doesn't look to me like this is what you would normally think of as the military, but there are enough factors here that I wouldn't be confident that it's not.
Yeah, I mean, so I think that's right. There's still plenty of gray area here, and if not even more gray area than perhaps we were hoping there would be after the release of the guidance. So for those who haven't seen it, these were issued as frequently asked questions, and there were over 30 questions that are included in the document that came out just ahead of the effective date of the new rules. I think the overarching point that Tim was referencing before, which is, well, how does the new military end use definition really change what it means to be a military end user? You have the traditional, easy to identify military end users. They did, and I'm talking now about question 3, they did say well, there's this other category, other military end users, which would cover foreign national government organizations as well as state-owned enterprises, SOEs, or other specific entities that develop, produce, maintain, or use military items. The problem there is the or. The
Right.
or still encompasses just about anybody in China. And that was the problem that we talked about when we did the original episode. What limiting principles do we have there? And it seems from looking at some of the other questions and some of the other feedback here that there aren't many, and there at the same time there aren't really too many bright lines. So it's not necessarily that one tie is enough to automatically make you a military end user, but it may be. It depends. It's all based on facts and circumstances. And the due diligence, the fact that the due diligence that companies are going to have to do is a bit of a moving target is problematic. I mean, as a practical matter, to just administer something like this, it's very challenging. And I think, to Tim's point, it's either going to result in lots and lots and lots of guidance requests and license applications that are coming in the near term, or quite frankly, companies might work up an analysis on their own where they say, look, we've done this based on the guidance. We feel comfortable. We don't have actual knowledge, or even we think knowledge that would be chargeable to us as a should have known standard, that this entity is a military end user. We think we're okay, we're on the right side of it, we're going to go ahead and export. I mean, that could very well be the way that some, in sort of the risk-based approach and like taking a thorough look at it, companies are going to do that for sure. And we know some of them, and others are going to be running to BIS for every possible wrinkle here. I think I would also add two other thoughts here that jumped out at me in the FAQs, and we could spend hours talking about these FAQs. We don't want to put everybody to sleep, number one, and number two, we don't want to have a 5-hour podcast. But if you look at question, now I'm going down to question number 9, which talks about parents and subs, and this is a bit like what Tim was touching on before. And it's trying to ask the question, it's trying to address the issue of, well, what if an affiliate of my client, my customer, my end user may have some military ties? Is that enough? And again, essentially, I'm paraphrasing here, but essentially the guidance is you have to exercise due diligence to determine whether the parent or sub and those activities, those military activities, are relevant to your end user's activities. That's basically what they tell you. So is that helpful? I don't know. I think it's questionable whether it's, again, all due respect to our friends at BIS, who I know are trying to do the best that they can, but this does leave, I think, a lot of big question marks here in terms of how people will be addressing these things. One area, though, that this is my last comment, where I do think that there is maybe a little bit that was cleared up, is there's a question that came up a little further down. This is questions 11 and 12, which talk about sales through distributors and intermediaries and third parties, when there's knowledge that those distributors may have end users, military end users, among their client base or their ultimate end user base. And the question is basically, if I sell through one of those distributors, do I then have knowledge that my items are being sold to a military end user? And essentially the answer is no, you don't necessarily. Now, they caveated, of course, to say if you have specific knowledge that something's going to be rerouted to military end user and it's on the supplement 2 list, then perhaps that is enough to constitute knowledge. You would have to come get a license. But otherwise, a normal sales process through a distributor where you have no specific knowledge of any sales that are going to military end users, that doesn't necessarily convert that distributor or intermediary to a military end user. So I actually did think that was somewhat useful, because that is a question that comes up a lot with any big entities that are making high volume commercial sales into China.
No, absolutely. That was helpful. And I think, I mean, I do want to put a kind of a marker on one of the points that you made, Brian, that I think is key, but I also think it prompted this guidance. So the rule says that in order to go get a license, you have to have knowledge that your end user is a military end user. And I think one of the things that is a theme throughout this guidance that likely prompted it is they don't want companies to come in and say, well, we have no knowledge that this company is a military end user, so we don't need to go get a license. And so they highlight the sorts of due diligence that you have to do before you can say we have no knowledge. You can't just kind of look the other way and say, guess we didn't find anything to show us that they're a military end user, so we don't need a license. And I do think that, you know, you're right. I thought that the clarity that they brought to the issue with respect to subs and universities and distributors was in some ways better than I expected, because I was very worried that for all of those, the answer would be that if you had one instance that either a distributor or a sub or certainly a university had done any business with the military, that would create an automatic rule that you had a military end user. And they didn't say that at all. They do make it very clear that it's a case by case analysis that is going to turn on the specific facts, and there's no one fact that is going to necessarily be dispositive. And it strikes me that, you know, with the distributor example and some of the others, that they are at the end of the day saying, if you do your due diligence and you still don't think that this is a military end user, you don't need to get a license. But what you can't do is you can't just say, hey, we're not going to look, because if we looked, we might find out it's a military end user. The last thing I'll say is that there was also something that kind of to go against that, but also I think plays in with the subsidiary issue. The Defense Department put out a list almost immediately before the due date of companies that are in the United States, but they believe are owned or controlled by the Chinese military. And there were a lot of companies on that list. And I think that to the extent that what they were trying to do on the parent subsidiary with the guidance was say one thing, I think they put out that list to also kind of send a message in the other way, in essentially saying, you know, this is another thing that we think that you are now on notice of. You can't deny notice of this in terms of making that calculation.
Yeah, no, I think that's right. I would just add also, just to be clear, I wasn't suggesting that any companies or clients of ours certainly would take the bury your head in the sand approach to compliance here.
No.
In fact, BIS there was a question 15, which links to BIS's KYC guidance. And so I think everybody should expect that at the minimum is what would be expected of any companies that are conducting sales with any entities that are even arguably in the realm of military end user. But that being said, I think Tim is right that it's not necessarily that if you are uncertain or you've gone through the necessary or expected steps to do that analysis and you can't conclusively say, which of course in many instances some of this is going to be unknowable, and it is information that is uniquely in the possession of that end customer and user that a company in the US or elsewhere around the world trying to do that KYC work is just never going to be able to get, then that may be enough, and you don't necessarily have to go get a license. Now, I think you are still, as a practical matter, probably bearing some risk of having gotten it wrong there, but nevertheless, I think the message is not necessarily that please come to us for any time you sell to anybody in China because we're treating everybody like a military end user. It is the same message that is consistent at BIS and elsewhere in OFAC and other entities, which is we expect you all out there in the world to be applying risk-based compliance protocols to assess and do appropriate due diligence on your customers and the people you're selling to and through and doing business with. And even once you get through, if you exhaust that process and you still don't have a comfortable answer or it's still unclear, we're here to answer your questions and help you out. So that's not all that different than how all these things get handled pretty much all the time. So with that, let's turn now to our third and final topic of the day. Again, another China topic, which sort of comes to some degree out of something, again, that we talked about quite a bit recently, which is the Uyghur Human Rights Policy Act, which was just passed and signed into law a few weeks ago. This is not, strictly speaking, only a byproduct or a result of that act, although I think the timing was such that they were likely waiting for that to become enacted before this was put out. So this was last week as well. that there was a joint advisory that was issued by State Department, which was sort of nominally the lead on it, Treasury, Commerce, and Homeland Security, that put out an advisory relating to Xinjiang supply chain risk for businesses. And Xinjiang is the region where the Uyghur and other internment camps and facilities, re-education facilities have been set up in China. And the general thrust of the advisory is to put companies on notice of sourcing any product or having any supply chain touches to that region, because you may ultimately be using and benefiting from the use of forced labor in your supply chain, which has taken on elevated significance in the last couple of years in US sort of compliance circles and protocols. It's something certainly that DHS and CBP, Customs and Border Protection, have emphasized and are enforcing probably more frequently than many other agencies are at this point. And so it is sort of a notable thing to be putting out guidance like this. And like some of the advisories that we've seen in recent months, this sort of follows that same pattern, where it's a bit of an everything but in the kitchen sink approach to this advisory, where there's a lot of factual background information about the camps in China, the use of forced labor, the types of industries that forced labor is being used in, including there's an appendix that's attached that includes industries where there are particular concerns about the use of forced labor on a regular basis, and it also takes the opportunity to that's Annex 3, by the way, to the advisory. It also takes the opportunity. I do think it's interesting to emphasize, and this is, I'm certain, purposeful, to emphasize the potential reputational, economic, and legal and other risks that businesses take on when potentially doing business or having their supply chains touch upon the Xinjiang region in China. And so one thing that, and I should say, much like many of these other advisories, is a section later on in the advisory where the advisory walks through kind of the laundry list of different kind of legal problems that you can run into, whether it be unwittingly doing business with companies on the entity list. And BIS just placed 30 plus entities on the entity list about a month ago, most of whom were tied to this type of activity. So that's again, sort of a timely follow-up on that. Some of the other legal authorities that exist there, but it's not primarily, I would say, about the legal risk. It is to some degree. I read this more as a couple things going on here, and I'm curious to get your thoughts on this. One is, I think this is a real sort of warning shot to big US based companies that have known ties to this region. And there are some, it's been reported, there's a number of companies that have been reportedly tied to the region that for liability and other reasons, I'm not going to mention any of them by name on the podcast, but you can find them if you look in some of the reporting that's out there on this topic. And so I think it's again, by starting with reputational and economic risks, I think it's an attempt by the US government to sort of use that power of persuasion to get those companies to sort of back away from having any ties and to work proactively to take those ties out of their supply chains. That's number one. And number two, again, the sort of the legal element of it, although there are considerable legal risks, that is not really what's front and center here. It's really constructed more as a written toward the compliance program managers, the chief compliance officers, those types of folks, and perhaps trying to elevate the idea of business and human rights, as it's often referred to, and forced labor considerations into a more, a focal point of compliance efforts, and trying to get people to integrate those concepts into their compliance program. So that's a lot of what I think is going on here. So there are some practical elements of it. Obviously, they're warning about some specific things and specific problems that companies can run into if doing business or having any supply chain partners that are in this region, certainly of China. But at the end of the day, I think this is in part sort of a plea to, again, sort of elevate those issues to perhaps a higher level of awareness and understanding than they've gotten maybe in a large audience to date. So I'll stop there and throw it to you, Tim, to get your thoughts.
I don't have a huge number of thoughts on this, but I was struck by a lot of the same things that you mentioned, Brian. I mean, I guess what I will throw out is that it is kind of unusual that this quickly after the sanctions authority went into place, you have an advisory kind of targeting that region that is signed off on by state, Treasury, Commerce, and DHS, all kind of pointing kind of almost as an afterthought to the legal risks of doing business in Xinjiang, but also to the reputational risks and really kind of highlighting the reputational risks if you include this area of the world in your supply chain. And so, we'll see if this is a development towards the government agencies really getting serious about human rights and what they go on to describe as forced labor and human trafficking concerns, or if it's just really targeted at kind of another swipe at China that is not going to be reflective of a more global focus on these sorts of issues. But the speed with which it came out and the fact that they went against reputational interests and kind of highlighted the reputational risks that a company takes place if it does business in this area was, I thought, very interesting.
Yeah, I think particularly to follow on to your point, which I think is exactly right, one of the centerpieces, and again, the State Department really took the lead on the rollout of the advisory last week. Treasury in particular was sort of surprisingly muted on this, but again, sanctions and their sanctions programs were not really front and center in the advisory. So to some degree, state taking the lead does make sense. The Secretary Pompeo did make a statement, but the centerpiece of the rollout was really a letter from the Undersecretary for Economic Growth, Energy, and the Environment, Keith Cratch, and it's literally titled "Letter from Undersecretary Cratch to Business Leaders on Xinjiang Supply Chain Business Advisory," and it's worth a read. It's about a 5-page letter that you can pull off the State Department website, and it does exactly what Tim was just describing, which is this is really I think a plea. It's a little more carrot than stick than we're used to seeing these days, I think, in terms of trying to appeal perhaps to reason, morality, and common sense more than threats to get people to do what we want them to do, we being the U.S. government. So that letter from the Undersecretary at State, I think, is worth a read. And again, given that economic growth is his bailiwick, I think that is what I said earlier, sort of the idea that there's some big U.S. companies that they're trying to perhaps budge off of their ties to the region in an effort to maybe move the needle on this. I think that really strikes me as kind of the number one purpose that they're aiming for here.
Yeah, we'll see how it works.
Yeah, like with anything else, we'll see how it works. We'll also see. I also think just one last comment, which is, although the Uyghur Human Rights Policy Act just went into effect a couple of weeks ago, I think there were maybe 2 sentences on that in the advisory. Perhaps it was drafted and they weren't sure if it was going to be ready before or after that was passed. There is, however, about half a page on the Global Magnitsky Act, which, as Tim and I have pointed out before, was an authority that was already in place to go after anybody who is potentially violating now the Uyghur Human Rights Policy Act. So it's interesting that they spend half a page talking about GLOMAG, as it is often referred, and how that parties could run afoul if they're dealing with persons who could become designated under that, or by your actions in the region could yourselves become designated. So I did think that was interesting, but in any event, that is a real sanctions nerd deep cut for all of you out there who are listening. So with that, I think we're going to end the main portion of the show for today, and I will pause for the lightning round sound effect. And with that, I'm going to turn it back over to Tim to introduce our first of only 2 two topics today in the lightning round.
And these will be real, like lightning round discussions, I think. I mean, the first one that we wanted to talk about was, the Venezuela-Iran link that I think has been driving people over at the Treasury Department nuts, because there was so much publicity as these tankers from Iran came to Venezuela, and there were articles about the sanctions implications of really probably the two highest sanctions priorities kind of getting together. And in some sense, it's like the Penguin and the Joker from one of these, Batman movies. They're uniting their powers together to take certain actions. And I think that's certainly how the Treasury Department seemed to view it. And so as you saw these articles come out, it was relatively inevitable that that the Treasury Department would try and use sanctions as a way to deter this sort of action or to punish it, and that is what they did on June 24th. 5 of the Iranian captains who were delivering gasoline to the Maduro regime were put onto the SDN list, and the statement was really, as you would expect, and I think that the idea, and it's been pretty common recently in connection with Venezuela, is that the way to stop the illegitimate oil trade in Venezuela is to go after the ships. And here, I think they went after the captains. And kind of the other end to that is that in Venezuela in particular, and we've talked about this on other episodes, I think you've talked about it a lot, Brian, is that not only are you seeing these ships go onto the list quickly, you're seeing them come off the list with almost lightning speed. And so almost at the same time that the 5 Iranian captains went onto the list, we had a bunch of tankers that had been designated previously by the Treasury come off the list. So we had on July 2nd, we had 1, 2, 3, 4, 5, 6, 7, 8 tankers that had been designated under the Venezuela sanctions that came off the list, presumably because they had gotten their risk-based compliance program in order and promised that they were no longer going to do business with the Maduro regime.
Yeah, that's really the only thing I want to comment on is that, yeah, the eight removals from last week and the ending of a general license that had been put in place just about 2 weeks before as well. That was for wind down purposes with some of those entities. I think it's actually a mix of vessels and shipping companies that were taken off the list. But to Tim's point, we noted this, I think it was in the very last episode, that that's an interesting, now I think we can call it a trend now that we've seen it a second time, that quick on the list, quick off the list is something that OFAC seems perfectly willing to do when it comes to illicit oil trade with respect to Venezuela, whereas we don't see that really anywhere else in any other programs.
Nowhere.
And so, yeah, so keep an eye on that, and if you're somebody out there who's got a vessel on ice because it's been blocked, then you should really think about going to OFAC and committing to not helping the Maduro regime any longer, if that's a possibility, because it seems that that's and abiding by risk-based compliance procedures, because it seems that and we don't have the specifics on this go around, but it seems like that's likely what the commitment was to get these folks off the list as well.
Lightning speed removals,
Yep.
custom made for the lightning round.
Exactly. And with that, let's go to the final topic. So this is especially lightning round with just 2 topics today. So Huawei, as I mentioned at the outset, we can't get through an episode without talking about Huawei. So one thing we did want to circle back on, and there was an article or a piece that prompted this, and I'll give credit, it was in CNN. It was posted on CNN a few days ago, and it was basically positing the question: what kind of trouble is Huawei really in? Is this sort of just a political game that the U.S. is playing? What does this really mean for Huawei, sort of big picture? And I think what this sort of kicked off for us, and this is something that has been written about a lot and we've talked about a lot, maybe not on the pod, but off the pod, is what are other countries going to do with respect to Huawei? Because at the end of the day, putting aside the amendment to the foreign direct product rule and the entity listing and the government contracting restrictions that are about to go into effect and all the rest of it with respect to Huawei, this is all about a battle for 5G infrastructure and supremacy in 5G infrastructure. And in the US's view, keeping Huawei out of that game certainly in the US, and as much as possible elsewhere around the world, because of the fears of the security hazards that means in terms of providing data and access to communications and other data back to the government in China. And so, not surprisingly, the US is engaged in quite a bit of lobbying among allies and others around the globe to try to get other countries on board with our view of the threat here. And there have been a few that have come along pretty quickly and willingly. I think those are close security allies like Australia and New Zealand, but just about everybody else is kind of held out. There have been a number over the last year or two that have fallen into place in Europe and other parts of the world, but big economies, big countries where this is a big question for whether Huawei is going to be involved in the 5G infrastructure build in the UK, in Germany, in France, places like that. This has been a sort of big question mark, but now, I think there's an added layer, which is with the US restrictions and with the supply chain restrictions that Huawei now faces itself under as a result of the taking some of the foundries perhaps out of circulation for Huawei, even with the stockpile they've built up of chips. Will they be able to deliver? Will they be able to actually provide that the networking and infrastructure needs that are going to be demanded of 5G if these restrictions remain in place? So in some strange way, this little echo chamber of the US's construction has perhaps started to influence others in ways that maybe weren't anticipated at the outset here. So I think it still remains to be seen where various countries are going to come down on this, but I do think that pay close attention in the next few months to how countries are dealing with this issue. And if you're listening in a EU country in particular, any of the ones that we mentioned, Germany, France, and the UK especially, be keeping a close watch on this, because this is a big deal. And I think those countries are taking a more measured approach here. They're trying not to politicize this, and they're trying not to be seen, for obvious reasons, as doing the bidding of the U.S. when it comes to coming to a view on this issue. That being said, it's very possible that some, if not most of them, may ultimately end up aligning largely with the U.S. on this issue. So I'll stop there.
Yeah, well, so Huawei has proven very resilient. So I think it would be best not to underestimate their capacity. We've seen how they've stockpiled chips, but that all said, this is potentially a really significant development with respect to whether or not it can continue to thrive despite being placed on the U.S. entity list and despite all of the kind of tweaks to the entity list rules that the U.S. has made precisely with Huawei in mind. And it suggests that this last one that really was designed to limit Huawei's ability to get chips for its 5G equipment may have had a serious effect. Now, the real key to this, from what we're looking at, is what will the UK do and what will Germany do? And there's signs that the UK and Germany are actually going to start really trying to wall off Huawei in much the same way that the US has. And for entirely different reasons, India is going down that road and looks much more likely to stick. And so between those three pretty big economies, actually, if they essentially join the US side on this with respect to Huawei, they could start to feel the pain fairly quickly. And I think then the question is, well, what happens next? Do they just accept that, or do they come to the table and start talking about ways that they could address the concerns of the U.S., the UK, and Germany? I think India is different because there's at least partly a shooting war going on between China and India right now, and so I think that's what's driving that. But with respect to just the pure trade issues, I think this is definitely worth watching, and I think that we'll probably be talking in the next episode about what Huawei's kind of counter move is to this. Their reach out to the UK, reach out to Germany, or potentially they'll reach out to the US, but somehow they're going to have to deal with this development if it turns out to be real.
Right, or do they double down on the strategy that they've largely employed in the U.S., which is to be highly litigious, which is to just take everything to court, challenge everything, and try to fight that way? And that could that could also be what we see in some of these other countries. So yeah, agree. I think don't count Huawei out by any stretch. I did not mean to signal that that they are down for the count. But in any event, I think this is worth, again, keeping an eye on the sort of broader view, not just the U.S. view on Huawei and how that's going to play out in the coming months.
All right.
So with that, I think we're wrapped for today. Thank you to everybody for joining us once again. Again, hopefully everybody in the States certainly had a good 4th of July weekend following on a good Juneteenth holiday a couple weeks before. And we're looking forward to coming back in a couple weeks. Again, perhaps we can muster up some non-China content in 2 weeks if circumstances align right. But again, thank you for everybody tuning in. Please subscribe, please give us a rating. And until next time, stay safe, stay well, and stay sanctions free. Thanks, everybody.
More summer podcasting to come.
Yes. Thank
Stay
you.
sanctions free, everybody.
Until next
Thanks.
time. Thank you. Bye.
Bye.